All right, we have two cases here involving the same defendant, both state will have this Rachel and Grooms, case number 21 CR 84, 21 CR 161. Appearing on behalf of the states, Assistant Prosecutor King. Appearing on behalf of defendants, Attorney Jacob Wagner, and you are Rachel and Grooms.
Yes, sir.
All right, in case number 21 CR 84, the defendant is charged with 2 counts of aggravated trafficking methamphetamine, 2 counts of aggravated possession and forfeiture. In case number 21 CR 161, she's charged along with co-defendant with 3 counts of aggravated trafficking methamphetamine, 3 counts of aggravated possession. This matter is set today for hearing and on the plea, and I have been handed plea agreements in both of these cases, Ms. Grooms, that indicate that you're going to withdraw. You're not going to plead guilty to looks like the first count in each case.
Yes, sir.
Now these documents are prepared by the prosecutor's office before. They're 3 pages long. On page 3, there are signature lines, and there's a sentence on the 3rd page that reads, "I enter the plea voluntarily." Immediately below that is a line for signature defendant, and I see what appears to be signature Rachel Grooms on each of those pages. And is that your signature that I'm looking at?
Yes, sir.
When did you sign these agreements?
Just now.
Okay. Now, did you go over them with your attorney before you signed them?
Yes, sir.
He explained everything to you?
Yes, sir.
Did you understand that there are agreements to plead guilty, which means that there won't be a trial in either of the cases, and the next step would be a sentencing hearing?
Yes.
And is this something that him had been talked about previously?
Yes, sir.
So when you came here today, is this what you expected to happen?
Yes, sir.
Think you've had enough time to fully consider this matter before making this decision?
Yes.
And are you entering into the agreement to plead guilty in each case voluntarily?
Yes.
Right now, in case number 21 CR 84, it says that you're going to withdraw, you're not going to plead guilty to the sole count, or the first count, I should say, of the indictment, aggravated trafficking in methamphetamine under 2925.03A1, a third-degree felony. And in the 21 CR 159 case, says you're going to withdraw your not guilty plead guilty to aggravated trafficking of drugs, and section 2925.03. It says A2, that should be A1, shouldn't it, Mr. King?
No, it's A2. It's
A2
possession with intent to distribute as opposed to an actual trafficking case.
Pardon me now?
It's under the A2 section. It was not a hand-to-hand transaction. It was just an amount. In the old days, would have been referred to as possession with intent to distribute.
Right, but
Which case number are you referring to?
21 CR 161.
That's a different.
Oh, I'm sorry. Yes, it is. That's Ms. Jones's case. I'm sorry. I switched the files when I put the pleas on. I'm sorry. So in the second case, 159. 21 CR 159 is Ms. Grooms, and it's aggravated trafficking and methamphetamine, aggravated possession of cocaine. And you are correct. It is 20. Okay. Good thing I was looking at that. All right. I had myself confused. I'm sorry. So you're going to plead guilty to count 1, which is 2925.03A2, and case number 21 CR 159, which has a 3 charge. And it indicates that you understand that's a second-degree felony.
Yes.
Now, the maximum penalty is listed in the middle of the first page, and for the 21 CR 84 case, the F3, it states that you understand the maximum prison term for that could be 36 months. The minimum is 9 months, and there are different levels in between those 2 ranges. There's a fine available of up to $10,000. There's a mandatory fine of $5,000, and a possible license suspension of 6 months to 5 years. Now, on the 2925.03A2 case, in count 1 and 21 CR 159, it states you understand that the maximum term for that, if prison could be imposed, if it is imposed, would be 8 years, and there's a minimum of 2 years. And in this case, Prison term is mandatory. There's no community control. It's marked out on your vote on your sheet. And so what happens is the judge can sentence you to any number between 2 and 8 years. And then because of law that in effect about 3 years ago, the post law, for a first or second degree felony, the Department of Corrections can require someone who is sentenced to a period of incarceration under that law to serve longer than the term set by the judge. And they can require you to serve up to an additional 50% or 1/2 or whatever sentence ordered by the judge. So for a worst case scenario, which is what I have to explain to you, the most of you can receive from the court if you plead guilty to this offense will be 8 years. But under the law, it could be held in custody for up to 12 years if the Department of Corrections felt that that was appropriate. You understand that?
Yes, sir.
Okay. Now, as I said, in 159, this is a non-probationable case, so there's no community control, there's no early release. And so whatever number I set as a minimum, you have to serve. Now, beyond that, then that's up to the Department of Corrections. And the sentences could be ordered to be served consecutively, meaning one after the other. So if you get maximum prison term of 8 years in the 159 case, and the maximum of 36 months to 3 years in the 84 case, that would total up to a maximum possible prison term of the two charges of 11 years as a minimum. Half of only the other account, which is in the 159 case, which is 4. So it could be 11 to 15 could be the maximum. There could be a maximum fine of $25,000, because there's a fine available for 59 to 15,000, and a mandatory fine of half that, 7,500, and then also the license suspension 6 months fine. Now you understand all of that?
Yes, sir.
Okay. Now, other than these charges, are you currently facing any other felony charges in any other jurisdiction?
Yes, sir.
And you are serving a prison sentence out of Warren County?
Yes.
And what's your out date on that?
March 18th.
Of this year?
Yes, sir.
All right. Well, if you're sentenced to prison in these cases, the terms could be ordered to be served consecutively to each other, plus consecutive to whatever term is out of Warren County. Even if they were to be consecutive, they will only start from today, so you would have just a few days anyway, so it really doesn't make much difference. You just need to play that. You understand that?
Yes, sir.
Okay. And you're not facing any other felony charges anywhere else?
No, sir.
And other than the Warren County sentence, you're serving at least 2 charges. Are you on felony probation, parole, community control, or post-release control for any felony?
No, sir.
All right. Now, both of these offenses carry the have a post-release control factor. Post-release control means after a person has served the sentence ordered by the judge, the parole authority can continue to supervise people for a period of time set by the statute under the rules and regulations they adopt, and that's called post-release control supervision. The judge is involved in this control. Now, in 21 CR 84, post-release control is optional, and that means it wouldn't have to be done, but it could be, and it would be a minimum. It would be a term of up to 2 years. Now, I'm sorry, 3 years, because this is an F. Now, this is an old form. It says felony 3, 4, 5. 3 years. It's actually 2 years, isn't it?
I got a new form.
Yeah, the 159 case is new.
Up to
Yeah.
3 years, Judge. Yes, I got it.
Wait a minute. Let's see here.
I would refer to the language in the 159 form would be updated, so I would refer to that.
Yeah, if it's a felony of the 3rd degree that's not a felony of violence, or a felony sex offense, or for a felony in the 4th or 5th degree, it may give up to 2 years. So it's 2 years, not 3. So, yeah. But you guys have destroyed this old form.
I do.
Yeah, so I'm going to change that to 2 years. Now, that's optional. Now, that really doesn't matter, because in your other case, 159, it's mandatory. And so, even if they didn't put you on post-release control on 84 case for 2 years, under the statute applies in 159, you have a mandatory 3 years post-release control. So you will get post-release control on the 159. And whether or not to add the 84 to that or not, I don't know. It's optional, but it can only be 2. And it could only be 1 of the other. It would only be 5 years, 2 years would be at the same time, basically. Now, what that means is that if you violate any of the conditions that the parole court establishes for your supervision, they can return you to prison and make you serve an additional period of up to 9 months for each violation that you commit, but there is a cap, a limit of half of the prison term that's imposed by the judge for all violations. However, if you commit a new felony while under post-release control supervision, then in addition to whatever sentence the judge in that new felony case could impose upon you, that judge would also be authorized to sentence you to an additional period of 1 year, whatever time is left on that 5 years of, or 3 years of post-release control, whichever is greater. And let me back up. That's 18 months in the minimum with 3 is the maximum. They changed it. It used to be 3 years. Now it's 18 months minimum. So back up. It's going to be at least 18 months on the 159, but the maximum is 3. Then it will be at least 18 months. Whereas on the other one, it's possibly 2. So hopefully you understand that.
Yes.
Okay. So if you commit a new felony while under post-release control, then in addition to whatever sentence that judge in the new case can impose, that judge can sentence you for committing that offense while under post-release control in the 159 case to 1 year, whatever time is left on the amount of post-release control that was set, between 18 months and 3 years, and whichever amount is greater. And then if that occurred, that would be ordered served consecutively with the sentence in the case. You understand that?
Yes.
All right. Now, as I said in 21 CR 159, I don't have any authority to put you under control. I do have authority to put you under control 21 CR 84. Community control is what people know to be probation, which means you're supervised by a probation officer on a term set by a court for a period of up to 5 years. And during that period of time, they determine that you have not complied, and the probation department has to file a notice of that in court, and you'll be entitled to have a hearing to test that, and be represented by an attorney, and if the outcome of the proceeding was that you failed to comply, at that time the court would go to community control, you sentence you 36 months to fine $10,000. You understand that? Right now, the 21 CR 84 case, it alleges that on or about November 4, 2020, Huntington County, Ohio, you did knowingly sell or offer some methamphetamine, Schedule 2 controlled substance in an amount equal to a preceding bulk amount, or less than 5 times bulk amount. The violation of section 25.0381, so that's the third degree felony. Now, in the other case, the 21 CR 159 case, the first count alleges that on or about May 5, 2021, Huntington County, Ohio, that you did knowingly prepare for shipment, ship, transport, deliver, prepare for distribution, or distribute methamphetamine, a Schedule 2 controlled substance in an amount equal to or exceeding 5 times bulk amount, less than 50 times bulk amount, when you knew or had reason to cause to believe the methamphetamine was intended for sale or resale by the offender or another person in violation of section 29.5.3A2. So that's the charge of aggravated trafficking in methamphetamine, which, even though the title says trafficking, most people think that means selling or trading. It, in this case, means preparing for sale or planning for sale. And that is the second degree felony, which carries the term, mandatory term of 2 and 8 years is set by the judge, up to 50% of whatever number the judge thinks to be served. In addition to that, by the Department of Corrections on the state side, and a fine of $17,500 and $15,000, and a mandatory fine of $7,500 and possible license suspension for 6 months to 5 years. Now, Mr. Griggs, do you understand what it is you've been charged with in each case, what the state said you did, and when, where, how they alleged you did it in each case?
Yes, sir.
Have you discussed the nature of these charges, the evidence in each case, the possible legal issues in each case, possible defenses you try to raise in trial in each case, and possible outcomes of the trial in each case with your attorney?
Yes, sir.
And are you satisfied with this advice and confidence in this matter?
Yes.
And has anyone threatened you to make you plead guilty to these charges?
No, sir.
And are you under the influence of any types of drugs or alcohol this time?
Yes, sir.
You're not taking any prescription?
Just for depression.
Okay, but does that affect your ability to understand what's going on, or to accurately relate your thoughts and analysis of things? Okay. Now, on page 2, 21 CR 84, there's printing in bold, and then plus some additional printing that's been written in ink. So I'll read that. Defendant shall enter plea of guilty to count 1, state and dismiss remaining counts, state and defense jointly recommend 24 months. Defendant will cooperate with the prosecutor's office. Defendant agrees to pay back money in the amount of $600 to the Highland County Task Force. So that's for the 21 CR 84 case. Now, as to the 21 CR 19.59 case, it says some of it's stricken out. So I'll only read the part that's not been stricken out in the blue ink. It's 2, 4, 6, 5.5 lines. It says defendant shall enter plea of guilty to count 1, state will dismiss remaining counts. State defense jointly recommend 2 years mandatory incarceration, consecutive term incarceration. Defendant is currently serving out of Warren County, consecutive 21 CR 84. Defendant agrees to cooperate fully with the prosecutor's office. Is that your understanding of the agreement?
Yes, sir.
Has anyone promised you anything other than that to get you to plead guilty in this case?
Yes, sir.
Anyone promised you anything in the other case? Not other than what I read.
Yes, sir.
Right now, Mr. Grooms, under the law, the matter of sentencing is up to the judge, not the parties. And so even though the parties agree as to what the sentence ought to be, I'm not required to follow that. So if you plead guilty to these two charges, once I've heard all the information that's presented to me regarding sentencing, if I decide that that is not the appropriate sentence, I could sentence you to as much as 8 years incarceration in the 159 case mandatory, and as much as 36 months in the 84 case, consecutive to each other, for a total of 11 years, and then up to an additional 4 years on the 159 case. You understand?
Yes, sir.
Now, do you hold any kind of license or certification from any state agency that regulates any kind of occupational profession?
Yes, sir.
Now, you have certain constitutional rights, you must understand, before it can accept your plea in these cases. So the rights I'm going to claim to apply in each case. First of all, you do have right to counsel, and Mr. Wagner is appointed representative in each of these cases. Not simply to work the cases out, but provide any defense that might be available to you under the law that you wish him to provide. So, if you decide that you do not want to enter the plea of guilty to either or both of these charges, he'll continue to represent you and defend you, including a trial if that's what you want. You understand that?
Yes, sir.
Excuse me. Now, in each of these cases, you have a right to have a jury trial, in which 12 people will be selected from a group of citizens that live in this county that are summoned for jury duty on your trial date. Once the 12 jurors are selected in each case, the evidence will be presented, and then the jurors in that case also be instructed on the law, and then they will decide by unanimous verdict, meaning that each juror would have to agree on the verdict in each case, so the all 12 have to agree on the verdict. Now, in the event that you decided you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up, your right to have a jury trial in that case or cases. And if that is the case, then instead of a jury hearing the evidence in that particular case, it would be the judge who would hear the evidence, apply the law, and decide whether or not to say truth or guilt by proof beyond reasonable doubt. Do you understand that?
Yes, sir.
Now, in each of these cases, you have a right to confront the witnesses against you and cross-examine them through your attorney, which means that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney has the right to ask questions. That's called cross-examination. The purpose of that would be to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Now, in each of these cases, you have a right to use the power of the court to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses you're uncertain going to come in voluntarily, you request court issues court orders called subpoena, and that forces those people to come to court to be available to testify if they want to, though they don't want to be here. It's the same way the state's witnesses are forced to come to court. Do you understand that?
Yes, sir.
Now, in each of these cases, Ms. Grooms, you have privilege against self-incrimination, which means you're not forced to give evidence in this matter at any time, including trial. So no one can ever make you testify. The prosecutor can't, the judge can't, you decide. If you decide not to testify, the fact that you did not testify cannot be used against you in either case by anyone at any time. And in fact, no one's even allowed to talk about it, except in one situation. If you decide not to testify in a jury trial in either or both cases, then the judge will instruct the jury that in that case or cases that because that is your right, they cannot consider it for any purpose. You understand that?
Yes, sir.
Right, under the Constitution, Ms. Grooms, you're presumed innocent in each of these cases until proved guilty by the state of Ohio by proof beyond reasonable doubt on every essential element of defense's charge. What that means is that the burden isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to put on any defense in either case. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state. Prove your guilt on every essential element of each offense by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Now, in each of these cases, you enter plea not guilty disagrees, plead guilty or not guilty, denied the allegations in the indictment, in each case, denied you committed any crime, and then exercised or invoked all of the rights that I've just described. Now, if you change your plea from not guilty to guilty, the guilty plea is the complete opposite of the not guilty plea. The guilty plea admits to the allegations, admits that they're true, and that you committed the crime as charged therein. And that plea waives or gives up all of the rights that I've just described for you today, except the right to have an attorney. You always have the right to have an attorney no matter what you plead. With that exception, the plea of guilty waives, gives up the right to have a jury or court trial. Waives, gives up the right to confront witnesses against you and cross-examine for your attorney. Waives, gives up your right to use the power of the court to compel or force witnesses to come to court to testify for you, just like the state. It waives, gives up your privilege against self-incrimination, because if you say you're guilty, that's what you find you guilty. And it waives, gives up your presumption of innocence, because if you say you're guilty, the state's not required to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives or gives up any right to file an appeal that you think you could have had up until this point in the case. Now, if I sentence you to the maximum sentence, or under the certain circumstances you could file an appeal, that would have to be filed within 30 days of your sentencing entry being filed. Now, do you understand all of that?
Yes, sir.
And are you a U.S. citizen?
Yes.
And are you entering into each of these plea agreements voluntarily?
Yes, sir.
Now, is there anything you'd like to discuss with your attorney before we go any further?
Understand everything?
Yeah.
All right.
Do you have any questions about anything that I've explained? Then is it your decision to withdraw your not guilty plea to count one in each of these two cases and enter pleas of guilty pursuant to the terms of the written agreement that pertains to that case that you just done?
Yes, sir.
Then as to count one in 21 CR 84, which alleges that on or about November 4, 2020 in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount equal to or exceeding bulk amount, less than 5 times bulk amount, violation section 2925.0381 of the Ohio Revised Code, a third-degree felony charge of aggravated trafficking methamphetamine, carrying a possible prison term of between 9 and 36 months in the increments provided by law, a fine of up to $10,000, a mandatory fine of $5,000, and a possible license suspension of 6 months to 5 years. How do you feel?
Guilty.
All right, and count one of 21 CR 159, which alleges on or about May 5, 2021, Highland County, Ohio, you did knowingly prepare for shipment, ship, transport, deliver, prepare for distribution, or distribute methamphetamine, a Schedule II controlled substance, an amount equal to or exceeding 5 times bulk amount, or less than 50 times bulk amount, when you knew or had reasonable cause to believe it had been intended for sale or resale by yourself, offender, or another person, in violation of section 2925.03A2, the charge of aggravated trafficking methamphetamine, a second-degree felony, carrying possible prison term set by the judge between 2 and 8 years, which would be mandatory, and an additional possible 50% of whatever sentence would be imposed by the Department of Corrections, in addition to that awarded by the judge, a fine of $15,000, a mandatory fine of $7,500, and a possible license suspension of 6 months to 5 years. How do you think?
Yes, sir.
All right, thank you. All right, the court finds on this date, open court, defendant was advised of all their constitutional rights in each case, made no intelligent voluntary waiver of the same pursuant to Rule 11. Plea in each case is accepted in order filed. Plea to count one, I should say. In each case is accepted in order filed. Defendant is found guilty of aggravated trafficking methamphetamine, a third-degree felony is charged in count one of 21 CR 84, and aggravated trafficking methamphetamine is charged in count one of 21 CR 159, a second-degree felony. The counts 2 through 5 are dismissed in 21 CR 84, and counts 2 and 3 are dismissed in case number 21 CR 159. Now, inasmuch as The sentence in 21 CR 159 is mandatory. There's no real point in the court not proceeding the sentencing immediately without a pre-sentence report. I don't believe there's one question. So I'm going to go ahead and proceed. So Mr. King.
Only was contained in the period.
All right, Mr. White.
You know, we asked the court to follow the recommendation of the parties. The court is aware that they have coordinated in the back where we appreciate it. Isn't it case for Rachel and driving on the beach? She just got a case out of Warren County, got back here Thursday, over the weekend, after this morning. She ends up to a contact general last court to follow recommendation.
All right, Mr. Grooves, anything you'd like to say?
No, sir, thank you.
As I understand it, you were indicted in 21 Sarah 159 while you were already in prison.
Yes, sir.
Okay. And 21 Sarah 84, looks like you were arrested on the 5th of May and held until the 7th of June. Does that sound about right?
Yes.
Okay. Is that how long you went to prison for Warren County?
I was in Warren County from July 18th to November 6th.
Okay, so you go right, and then you went to prison for there.
Yes.
All right. Well, serious charges the defendant has, as the attorney indicated, cooperated in this and accepted responsibility. We'll see that you have previous conviction out of this court back in 2015. Apparently, looks like you violated your probation twice and had it extended, and then the third time you were sent to prison. So, it is the judgment or the court that in case number 21 CR 84 that you be and are hereby sentenced to a term of 24 months in the Higher State Reform Court of Women, and to be given jail time credit of 34 days according to what the sheriff's record reflect, and we just discussed. The court will also order that you pay restitution in the amount of $600 represented by to the Hunter County Task Force. That will be ordered to be paid pursuant to the approved the victim witness office and pay their fees that they have charged with that actual service. That is a substantive order, which means that it will be there no matter what you do, even if you serve another day of your sentence, it will still be there and can only be discharged either by paying it or dying or bankruptcy. So you would require to pay that. Now, in case number 21 CR 159, it is the judgment or the court that you be sentenced to a mandatory term of 2 years of incarceration. And under the Reagan Codes law, that could be extended by the Department of Corrections to up to 3 years if they decide to do it 50% of the 1 year. There's no jail time credit on that. That sentence is ordered to be served consecutively to the sentence. In the other case, the court will find that these were committed as part of 2 or more courses of conduct, and that the harm caused by the one will not, or the harm caused is not accurate by the resurgence of the offenses. Also, the court finds that your history of criminal conduct is such that consecutive sentences are necessary for the public, and for the sentences were agreed upon by the parties. Now, upon completion of these sentences, as I said earlier, 21 CR 159 is mandatory to be put under post-release control, supervision by the parole authority for at least 18 months, and it could be up to 3 years. In 184 or 21 CR 84, it would be up to 2, and that is optional. But it is mandatory available, so we know you're going to have at least 18 months to be up to 3 years. Now, in the event that you violated the conditions that the parole authority establishes, then they have the right to return you to prison, making sure an additional period of up to 9 months for one violation, up to maximum half of the prison term ordered by the court about parole violation. Whether it's committed a felony, while under post-release control supervision, then in addition, whatever sentence the judge in the case imposed upon you, that judge would also sentence you in this case, or for committing that crime while under post-release control in this case, to an additional period of 1 year, whatever time to be left on that 18 months to 3 years of post-release control, whichever is greater. If that occurs, that would have to be served consecutively, the sentence in the new case. You're also ordered to pay the court costs, which judge written in the execution order. Now, has there been any financial change, any change in your financial circumstances since you were appointed counsel and then went to prison?
Yes, sir.
All right, the court will find that the defendant does not have the means and is unlikely to have the means in the near future to pay the mandatory fines, and therefore the court waives the mandatory fines. Anything further from counsel?
There you are.
All right, so remand back to custody, Mr. Green. Thank you.
Pretty good.
All right, Samaria Alaki Jones.
Make sure your phone's off, okay?
Case number 21 CR 161, State of Ohio versus Samaria Alaki Jones. President of the state is Assistant Prosecutor King. President of the defendant is J. Wagner. And you are Samaria Alaki Jones. Is it Alaki or Alaki?
Alaki.
I'm sorry. All right. So Samaria Alaki Jones.
Yes.
And that is you?
Yes.
All right. Now, the defendant is charged in a 6-count indictment, 3 counts of aggravated trafficking methamphetamine, 3 counts of aggravated possession of methamphetamine, along with Juan Anthony Anderson. This matter is set for a trial, I think, next month sometime. I remember the exact date. I think it was continued originally. It was set for February today. It was set for today, and with what had been going on, the court went ahead and just set it as a plea set the trial. Yeah. Thank you. Now, Ms. Jones, I've been presented with a plea of guilty form. It says you're going to plead guilty to a amended charge in count 1 of aggravated trafficking methamphetamine, a 3rd-degree felony, and a 2925-0381. Right now you're charged with a 2nd-degree felony. Now, this is a 3-page form. On page 3, there's a sentence, a little less than halfway down the page. It says, I enter this plea voluntarily, and right below that there's a line that has signature defendant. There's a little blue X there, and it looks like the signature Samaria Jones. Is that your signature I'm looking at?
Yes, sir.
Okay, so you don't sign it a little late?
No.
All right. And when did you sign this agreement, Ms. Jones?
I believe it was Thursday.
Friday?
Thursday.
Thursday? All right. And was that at Mr. Wagner's office?
Yes, sir.
Did you go over with him and have him explain everything to you so that you understood it before you signed it?
Yes, sir.
And you feel you had enough time to fully consider the matter before making a decision?
Yes, sir.
You understood that when you signed it was an agreement to plead guilty, which means there won't be a trial in your case, and the next step would be a sentencing hearing.
Yes, sir.
And are you entering into this agreement to plead guilty voluntarily?
Yes, sir.
All right, now the agreement states on page 1 that you're going to plead guilty, as I said, the amended charge, count 1. Currently, you're charged with a 2nd-degree felony because it's alleged that you sold an amount equal to exceed 5 times bulk, or less than 50 times bulk. So the amendment would be, I assume, counsel, that it would be over bulk, but less than 5 times bulk.
That's correct, Your Honor.
Okay. And so currently, the 2nd-degree felony carries a mandatory prison term with 2 and 8 years set by the judge, up to 50% more added on by the adult parole authority. I was just talking to Kate before, I don't remember listening on it. So what that means is it has a possible maximum prison term, a minimum of 2 years. And if you got a 2-year minimum, you have to serve, you could serve up to 3, because the DRC could add on an additional 1 year if they thought it was appropriate. But if you got an 8-year sentence, then it could be an additional 4, so that would make that 12. And that's mandatory time. The judge, whatever the judge says is mandatory. So if I say 2 years or 8 years, you have to serve it. No early release, no probation, etc. Now, by changing the allegation in count 1 from the amount involved exceeding 5 times bulk amount, but less than 50 times bulk amount, and instead changing that to an amount exceeding bulk amount, but less than 5 times bulk amount, that reduces the offense by 1 degree, which means that the maximum prison term is between 9 and 36 months in the levels provided by law. And a fine of up to $10,000, a mandatory fine of $5,000. But what it does also do is it's not mandatory. So you can get due control of probation instead of having to go to prison. There's also a possible license suspension of 6 months to 5 years. And that's all set forth there on page 1 of your agreement. You understand that?
Yes, sir.
I'm sorry, yes?
Yes, sir.
Okay. Now, Ms. Jones, are you facing any felony charges in any other jurisdiction?
No, sir.
Are you currently on probation, community control, parole, or post-release control for a felony from any jurisdiction?
No, sir.
All right, now, under the law, if you are convicted of this offense, and if you are sentenced to prison, then upon completion of that prison term, it is possible that the adult parole authority could, at their option, choose to place you under what's called post-release control for a period of up to 2 years. And if they did that, then you would be supervised by a parole officer in terms they set, because the judgment is involved in that. If during that period of time they determine that you failed to comply with those conditions, they could return you to prison, even though you served the entire term that was ordered by the judge, for an additional period of up to 9 months for one violation. But there is a cap or limit of half of whatever prison term was ordered by the judge for all violations. However, if you should be convicted of a felony while under post-release control supervision, then in addition to whatever sentence the judge in the new felony case would impose upon you, the judge could also sentence you to an additional period of 1 year or whatever time is left on that up to 2 years of post-release control, whichever is greater. And if that occurred, that would have to be served consecutively to the sentence in a new case, and that would be because you committed the new offense while under post-release control in this case. You understand that?
Yes, sir.
Now, as I said earlier, I'm not required to sentence you to prison for this offense. As charged, I am. It's mandatory. I have no discretion. But as amended, I can put you under post-release or under probation or community control, meaning you'll be put under the supervision of the county probation department for a period of up to 5 years under terms set by the court. If during that period of time probation felt that you were not complying, then the court could, or they would have to file a written notice of it, I should say, with the court, and give you a copy, and then the court will set a hearing, and you'll be entitled to have an attorney to represent you at that hearing. And if the court determined at that time that you had failed to comply, then the court would revoke your community control, and then sentence you to 36 months and fine you $10,000. Do you understand that?
Yes, sir.
All right, now, Ms. Jones, as I indicated to you, as amended, the indictment would read as follows. Excuse me, as follows. On or about January 8, 2021, in Hyden County, Ohio, Juan Anthony Anderson and you did knowingly sell or offer to sell methamphetamine, Schedule II controlled substance, in an amount equal to or exceeding bulk amount, but less than 5 times bulk amount, in violation of Section 2925.03A1. And that would be the third-degree felony with a possible prison term beyond 36 months. Maximum fine of $10,000, mandatory fine of $5,000, and a license suspension of possible 7 months to 5 years. All right, now, Ms. Jones, do you understand what it is you've been charged with, what the state said you did, when, where, and how they let you did?
Yes.
You understand the possible penalties for the amended offense?
Yes.
And have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, possible defenses you can try to raise in trial, and possible outcomes of the trial with your attorney?
You say, have I discussed?
Have you discussed your case with you? In other words, talk about what the charge is,
Oh, yes, sir.
you know, what the issues might be, what the evidence is against you or for you, and what might happen if you went to trial.
Yes, sir.
Okay. Are you satisfied with his advice and confidence in this matter?
Yes, sir.
And are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Are you taking any prescription drugs?
Like ibuprofen.
Okay, nothing that interferes with your ability to understand what you're being told or hearing, or to relate what you're thinking, or respond to.
No, sir.
All right. Has anyone threatened to make a plea guilty here?
No, sir.
Now, there's looks like about 5 lines that are printed in bold and underlined on page 2, and then see that the amount of the dollars in there has been changed. So I'll read it as it's been changed. Defendant shall enter plea guilty to count 1 as amended. State will dismiss the remaining counts. State defense join and recommend community control. Defendant agrees to cooperate fully with the state, testify truthfully against the defendant. Defendant agrees to pay back 5 money to the Hyden County Task Force in the amount of $2,450. joint and several with the co-defendant. Is that your understanding of the agreement?
Yes, sir.
Does anyone promise you anything other than that to get you to plead guilty here today?
Yes, sir.
You understand that as part of consideration for the reduction from a mandatory offense, that you will be expected to testify truthfully against Mr. Anderson.
Yes, sir.
And then as far as the restitution is concerned, joint and several means both parties, both defendants are responsible for the full amount, but to each other only half. But what it means is that if you pay and co-defendant doesn't pay, you would have to pay the full amount and have to go collect it if you're half the EO again. Because the law says the victims shouldn't have to chase multiple defendants. The defendants should chase each other. And so, that's the way that principle works. You understand that?
Yes, sir.
All right. Now, do you hold any license or certificate from any state agency that regulates any kind of trade or occupation in the city?
I was a CNA,
A CNA?
like a nurse aide, but my CNA had expired. It's not current, but.
Okay. All right. Well, and again, the reason I asked that is that if you are licensed, then we'll have to notify them. And so even though it's expired, the clerk will have to send a copy of the conviction to the nursing board because of the conviction, so that they'll be aware of it if you should apply and reinstate it.
Yes, I'm not state tested, so it might not pop up in the Ohio Board of Nursing. I'm not
Oh,
sure.
you're not licensed from them?
I'm not state tested, like I never.
Oh, okay, all right, then it doesn't matter.
Okay.
All right. It only applies to state testing.
Yeah, I'm not state tested.
All right, yes, well, then we don't have to worry about it. All right. Now, you have certain constitutional rights, as I understand, before I accept the plea of guilty from the first of all, you have the right to have counsel. Mr. Wagner is appointed representative. Now, he wasn't appointed simply to work out the case, like a plea bargain. It's whatever defense could be available to you under the law that you want him to provide. So if you decide you don't want to plead guilty, that you want to defend against these charges, then he'll continue to represent you, defend you, including a trial if that's what you would want. Do you understand that?
Yes, sir.
Right, you have the right in this case to have a jury trial, Ms. Jones, in which 12 people will be selected from a group of citizens who live in this county who are subject for jury duty on the trial day. After 12 are selected, they will hear the evidence and be instructed on the law. And that jury would have to decide by an unanimous verdict, all 12 have to agree, as to whether or not the state proves your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive the right as soon as you give up, the right to have a jury trial. In that case, you have what's called a court bench trial, meaning the judge will be the one to hear the evidence, the judge will apply the law. The judge will decide whether or not the state proves your guilt by proof guilty or not. You understand that?
Yes, sir.
Now, under the Constitution, you have a right to confront the witnesses against you and cross-examine for your attorney. What that means is that the witnesses against you have to come into court and testify in front of you, your attorney, and anyone else is present. After the prosecutor's done asking questions, your attorney will ask questions. That's called cross-examination. And the purpose of that would be to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to use the power of this court to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses that you're not certain are going to come in voluntarily, at your request, the court will issue a court order, that's called a subpoena. And that will force those witnesses to come to court to be able to testify if you wanted them to, even though they don't want to be here, which is the same way the state's witnesses against you are required to come into court. You understand that?
Yes, sir.
Right now, under the Constitution, you have a privilege against self-incrimination, which means that you cannot be forced to give evidence in this matter at any time, including trial. No one can ever miss to testify. The prosecutor can, the judge can, you decide. And if you decide that you're not going to testify, the fact that you did not testify not be used against you in any way by any person at any time. And in fact, no one is even allowed to comment about it except in one situation, and that is if there's a jury trial and you don't testify, the judge instructs the jury that because that's your constitutional right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Right now, under the Constitution, Ms. Jones, you are presumed innocent until proven guilty by the state of Ohio on every essential element of each offense charged by proof beyond reasonable doubt. So what that means is that the burden of proof isn't on you to try to show that you're not guilty. The burden of proof is upon the state to prove that you are. In fact, you're not even required to present any evidence in your own behalf at trial. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt of every essential element of each offense charged by proof beyond a reasonable doubt. Every essential element, as I said, which is the highest burden of proof that's known under the law. You understand that?
Yes, sir.
All right, now, originally you entered a plea of not guilty. Not guilty plea, denied the allegations in the indictment, denied you committed any crime, and then exercised and revoked all of the rights that I've just described. Now, if I change your plea, or if you change your plea, I should say, from not guilty to guilty, that accepted, then that is the opposite of the not guilty plea. The guilty plea would admit all the allegations in the first county indictment as amended, would admit that that's a crime, and will admit that you committed that crime. And that plea gives up all of the rights that I've just described for you, except your right to have an attorney, because you always have a right to have an attorney, no matter what you plead. So, your plea of guilty then would waive or give up the right to have a jury or court trial, waive or give up the right to confront witnesses against you in an open court, and have your attorney cross-examine. Would waive or give up your right to use the power of the court to compel or force witnesses to come to court and testify for you, just like you say. Would waive or give up your privilege of self-incrimination because you're the one saying you're guilty, that's what you find you guilty. Would waive or give up the presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives or gives up your right to file an appeal on any alleged violation of your rights that you think may have occurred. Now, if I sentence you the maximum sentence, or under certain circumstances, you can file an appeal. That will have to be filed in 30 days if your sentencing entry is filed. Now, you understand all of that?
Yes, sir.
And again, I want to emphasize that you understand I'm not bound by the plea agreement that's recommended. So if I decide that you haven't done what you're supposed to, or if I decide that the information presented to me says it should be a different sentence, then I could sentence you to prison. You understand that?
Yes, sir.
And you're entering to disagree with the plea guilty voluntarily,
Yes, sir.
and you're a U.S. citizen.
Yes, sir.
All right. Do you have any questions about the amended charge and possible penalties?
No, sir.
You understand?
Yes, sir.
Any questions about the plea agreement?
No, sir.
You understand it?
Yes, sir.
Have any questions about the constitutional rights I explained to you?
No, sir.
You understand them? Do you have any questions about the plea of guilty, what it means, what will happen if you enter that here today? In other words, you understand what will happen if you plead guilty?
If I may, sir?
Yeah, go ahead, talk here.
Whenever I told you, if you enter today, if you directly go back to probation, do that PSI.
Right.
Then we'll be back, judge will set it, they'll give you a date here in a second, probably 3 or 4 months, weeks, we'll come back. So if you enter a plea today, I can talk in the office, we go into the jury trial, take the plea, we come back for sentencing, and then that's when arguably you're done, so you cooperate with the state. You understand? Okay. I think she's fine now.
Okay. Now, do you have any other questions I'd like to speak to your attorney about?
Yes.
Go ahead.
Yes.
I was a little confused, okay.
I'm sorry.
I was just a little
Tell
confused.
us what you're saying. Yes.
All right. Do you have any other questions about anything that we've talked about here this afternoon?
No, sir.
And is it your decision then to withdraw your not guilty plea guilty to the amended charge in count 1 that we just discussed in this written plea agreement?
Yes, sir.
And as to the charge, amended charge in count 1, which agreed that on or about January 8, 2021, Highland County, Ohio, that Juan Anthony Anderson and you did knowingly sell or offer to sell methamphetamine, Schedule 2 controlled substance amount equal to or exceeding bulk amount of less than 5 times bulk amount, violation of section 2925.03A1 of the Ohio Code Code, a third-degree felony charge of aggravated trafficking methamphetamine, carrying possible prison term between 9 and 36 months in the increments provided by law, a fine of up to $10,000, mandatory fine of $5,000, and possible license suspension of 6 months to 5 years. How do you plead? Right, the court finds in this state open court, defendant supplies all of the constitutional rights made known, tells the voluntary to the same for such criminal law. Please accept the order filed. Defendant found guilty of the amended charge of aggravated trafficking and methamphetamine is set forth in the indictment and as amended on the record here today. Counts 2 through 6 are dismissed. Court will order that the matter be referred to the probation department for a pre-sentence investigation. Have you got an appointment to see them today or later this week?
I don't have an appointment, I just told them just to go
All
over
right,
there.
we'll just go down there as soon as we're done. They close at 4, so we'll need to get you out of here real quick, about 22. You know where it is right down the street.
Yes.
All right. So you report to them and continue to report as they tell you to, and they'll make the arrangements for your pre-sentence interview. We're going to set your sentencing for April 13th at 9 a.m. I think the co-defendant's trial is April 11th, so the 2 days before that. So that way your sentence will take place after that. All right. Is there anything further, counsel? All right, then you get a signed notice from the bailiff for your sentencing, and then hurry on down to the probation. All right, thanks, sir.
Please rise.